We just talked about the elements for murder. Now we're going to break down them. We're going to break them into their grades. So classifies murder in the first degree. When you hear murder in the first degree, what do you think? You think it's the worst criminal charge ever? Do you think it comes with the harshest penalty, i.e., like death? I pose this question. Do you think someone who actually plans to kill someone and puts that plan in motion and ultimately meets the objective should be punished more harshly than a person who decides to shoot a gun into a moving train of people? Or somebody who shoots their teacher because they got mad over a grade? Do you think there should be different treatment between the two? Common law gave us this malice and reckless that constitutes murder. Common law did not break down murder into degrees. If you acted with malice or with a depraved heart, both were considered murder. But most states have statutes that break them down into degrees. So premeditated, that's what we're going to need here. So what do we need? We need the killing that is premeditated, willful, and deliberate. You need those three things. It's premeditated, willful, and deliberate. Killings committed by individuals who, one, thought about the killing. They thought about killing the victim. Number two, they kind of stirred over it for a period of time. That constitutes deliberate. And they killed willfully. They killed. Premeditated. Let's talk about that for a second again. Defendant reflects. They acted, they planned. That's what premeditated is. How much time do you need? Not much time, actually. You can reach premeditation in a matter of moments. You think about it, and you're in a room, you've had an argument with somebody. They walk away from the room, and you notice the knife sitting on the counter. You pick it up, you look back into the room where the person went, and you go and you stab them. That could constitute premeditated. But for murder first, you also need willful and deliberate. So I want to give you an example of a case on premeditation out of the state of Tennessee. It's actually in the book at the tail end, but it doesn't give you much detail, so I want to go into it a little further. Mr. West was convicted of murder in the first degree, state of Tennessee, and he appealed his case, saying that there was not enough evidence to prove the element of premeditation. And his claim was, that failing to report the murder to the police, or the shooting, I should say, the failure to report the shooting to the police for over an hour and concealing the murder weapon is not enough for premeditation, claiming that's all the evidence that the state had to prove. And let me give you a little bit more of the case background, and then you can decide. So the law in Tennessee states that, let me give you the factual background first, then I'll tell you what the law is. So what the record, that's the trial, what happened in the lower court. Remember, the appellate court reviews the record of the trial court. The record indicated that on the particular day of the murder, the victim, whose name is Sam Jones, was mowing weeds along a roadside when he came upon the defendant, Mr. West, who was also on a tractor. No one else was present at this meeting. West testified that Jones insulted and threatened him, that West then went home briefly, and that upon his return, Jones attacked him with an iron bar prompting West to get off his tractor and shoot Jones in self-defense. That was West's argument, okay? Further evidence of the events after the shooting revealed that West waited an hour and a half before calling the police. Before the police arrived, West put his tractor and trailer away, went to the grocery store, and briefly visited a friend without mentioning the incident. After the police arrived and arrested him, West gave them permission to search the premises for the gun, and when they were unsuccessful in finding it, he eventually took them to the place where he hid it in some weeds. And that's it. The court points out that this evidence was quite sparse. The evidence was sparse. While in jail, Mr. West was treated for a scrape on his arm that he claimed that the victim inflicted with the iron bar, but there was an expert that said there was no blood on the bar. Medical examiner testified that a distant gunshot wound killed the victim and that the bullet traveled downward through the victim's chest and stomach, and which is an unlikely trajectory if West was shooting from the ground. So that was the evidence that the jury convicted him of first-degree murder. Okay? So the law says, defines murder as the unlawful killing of any reasonable creature in being and under the peace of the state with malice aforethought, either express or implied. Every murder perpetrated by willful, deliberate, malicious, and premeditated killing is murder in the first degree. So, what do you think based on that information? The prosecution argued that they did prove premeditation and deliberation. Their first reason of their theory was that after arguing, West returned to his home, where he retrieved his gun for the specific purpose of killing the victim. Well, Mr. West went from those facts, if you need to listen to them again, it doesn't say when he testified that he got his gun. He went home and then went back. His testimony was actually that he always had the gun with him, that he always had it carried on him. Another argument that the prosecution made was that the defendant's calmness immediately following the shooting proves that it was premeditated, that he was cool and dispassionate, that he did those other things. But there really wasn't any evidence in that record to show how his state was. So, as you can see where this is leading, the court said that the state failed to produce any evidence that the intent to kill was premeditated and deliberate. So they ended up reducing the charge. And I also want to point out here, because I'm going to talk about the meaning of deliberate in a moment, the court said the element of premeditation requires a previously formed design or intent to kill. And the fact that premeditation can be formed in an instant, it must be viewed in contrast with deliberation. And deliberation, on the other hand, requires that the killing be done with a cool purpose. In other words, that the killer be free from the passions of the moment. So think about those things. You can review this. The facts in the book are a lot less than what I just told you, but there is a link to the actual case if you wanted to read the entire case. So premeditated. How about actually I'm going to give you a couple more definitions and then we'll talk about another case that I had. So willful. Deliberate. Let's do deliberate. Calm and methodical, just like I told you from the West case, without any passion or anger. You just do it. There might be a motive. You don't necessarily have to prove motive, but if there is a motive and there's planning activity with regards to how you're going to kill or the killing itself, that's considered preconceived design. That's going to fall under our deliberate element. And willful, killed willfully, that is our criminal intent element. Remember, we can have willfully, we can have purposely, we can have intentionally. So willful is our specific intent, and that's what you need when you're actually doing the act of killing. You killed willfully. Okay? So all of those three things need to be met in order to constitute murder in the first degree. Now, in that the state versus West, the state did not prove premeditation. So let me give you another case. This is a federal government case. The United States versus Downs. This is also mentioned in the book. The definition of first-degree murder per the feds. They kind of work off the common law definition. A murder defined as the unlawful killing of a human being with malice aforethought becomes murder in the first degree when the killing was premeditated by poison, lying in wait, or any other kind of willful, deliberate, malicious, and premeditated killing. So they actually have some specific examples. We'll talk about those in a second, but the most important concept for my example in this case is any other kind of willful, deliberate, malicious, and premeditated killing. So let's talk about the facts of this case. Very similar. The defendant was convicted of first-degree murder, and we're on U.S. versus Downs. I already did state of Tennessee versus West. The defendant's convicted of first-degree murder, and he claims that the state did not prove the element of premeditation. So let me tell you what the evidence is, okay? Let's start with the evidence that was at the record. Downs selected the day of the killing. He picked out the day with care. At the time of the killing, these are the steps. At the time of the killing, his son and his daughter-in-law owned a house on which the victim, who is an ex of his, and that ex is a postal carrier. So at the time of the killing, his son, daughter-in-law owned a house on the ex's daily mail route. Without their knowledge, Downs made a copy of the key to their house at some point prior to the killing. By his own admission, the defendant decided to use his son's house to engineer some kind of encounter with the ex in violation of other term. He was under a term of probation. Though Downs claimed at trial that he intended the encounter to be no more than a peaceful farewell. Okay? So on his selected day, by virtue of his son and daughter-in-law's schedule, they weren't going to be present at the home at the time the victim made her rounds. So the day before, the defendant performed 4 acts, right? First, he rents a minivan with tinted windows, and he emphasizes to the rental agency clerk the importance of the tinted windows. Later that day, he removed the seats, disabled the interior dome light, and taped sheets of black plastic over the inside of the minivan's windows. Then he hid himself along the mail route to verify that a substitute was performing her duties. And as a former co-worker of the ex at the U.S. Postal Service, the defendant knew that the presence of a substitute virtually guaranteed that the ex would be back on her route the next day. And then he prepared and mailed 4 letters to his son's address. 3 of the letters were sent first class, 2 of them addressed in distinguished handwriting. The 4th letter was typewritten with a false return address, was sent certified mail, thus ensuring that the ex, the postal worker, would have to knock on the son's door to secure the required signature. And then the defendant and a close friend cleared the snow that was in his son's driveway, unused driveway ordinarily, and this was something that the defendant had never done before. So those are the steps, okay? So then on the morning of the murder, Downs arose early. He departed from his home. The record had showed that Downs had in his possession at the time a sawed-off shotgun, shotgun shells, a handgun, a quantity of hollow point ammunition, a sharpened knife, 2 blankets, two lengths of rope with loops tied at the ends, and duct tape. After waiting in the minivan for about 2 hours, he telephoned his son and daughter-in-law's house to confirm that they both left for work. And he arrived at the house, hid in the minivan in the garage, and entered the premises with his key. And when he was inside, he covered both sides of the outside screen door with black plastic. He loaded his shotgun and placed 2 extra shells in his pocket. He loaded the handgun with hollow point bullets and stuck the gun in his belt. And just inside the entry door, he waited for the mail to be delivered by his ex. Okay? With the loaded guns, an actual large metal club, and the rope and duct tape. What do you think about that? Is that premeditation? The court certainly said that was premeditation. And I believe they quote, "The evidence of planning thus firmly supports the district court's finding of premeditation." Now, something like that is certainly premeditation. Okay? Deliberate. How about the rest of the story? So I don't leave you hanging. They cite it in the book, but so how it goes down is she arrives, parks her postal Jeep out front. It's 1 p.m. He was there at 9 a.m. She began her mail route across the street. When she finally approached the door behind which the defendant hid, the defendant kicked open the door, chased her into the driveway, and shot her in the hip with the shot-off shotgun. And then there was witnesses. According to eyewitnesses, the victim, crawled on her back into the street. The defendant reloaded and fired off a second shot, missing her. Then he dropped the shotgun, then picked it up again, reloaded, and standing over her as she pled for her life, prodded her with the shotgun, and then fired a bullet into her head just above her right eye. Then he walked back up the driveway to retrieve his handgun that fell in the snow on his run out, and calmly returned to the victim and shot her 3 more times in the heart and once between the eyes. So there was an expert that testified that the victim's heart and lungs were still functioning after the first shotgun bullet to the head and before the handgun shots to her heart. Anyhow, deliberate, willful? Yes. I mean, that is probably a classic murder in the first degree type of case. So let's move on. That was first degree, and then our other degree of murder is murder in the second degree. There's nothing third, fourth, fifth. It's either 1 or it's 2. Number 1, it's murder. It's premeditated, deliberate, and willful. And if you don't have premeditation, it's not first degree murder. So think of it as if you don't meet those 3 elements, any other kind of murder is second degree murder. There's 3 and so what if let me ask you this question. What if a person acts recklessly? This is our shooting in the train. What if a person intends to break your leg but ends up killing you instead? This is me and my bat, and I go to hit the victim in the leg and I miss, and I hit him in the head and I kill him. My intent was serious injury. On that second one, the first one, I'm acting recklessly with disregard for human life, depraved heart. Under the common law, obviously that would encompass murder. But like I said, in common law, murder isn't defined as degrees. If you kill someone under those 3 scenarios, under the common law, you're guilty of murder. And whatever the punishment is for you, the punishment for murder is the punishment. But statutes, and this is the case in New York, is we have murder in the first degree for premeditated, and everything else that's considered murder without the premeditation is going to be deemed second degree. So this is where we would find where somebody acts with a depraved heart is under our murder 2 scenario. Or if you go to seriously injure somebody and you ultimately end up killing them, you're going to be in the murder 2 category. Let me see. 3. There are 3. I thought I had I don't have it on here. All right. So there are 3 steps you got to ask yourself when you're determining whether or not somebody has committed murder. Well, you have let's say you have a dead human being, right? You have the prosecutor or law enforcement who's doing the charging has to decide whether it's going to be murder 1 or murder 2. So these are the 3 steps. Was the killing a murder? Was it with malice aforethought? Number 2, was it premeditated, deliberate, and willful? And if you answer yes to number 1 and number 2, or number 2, it's either number 1 or number 2. If yes, you have first degree. If no, it's second degree. Okay? Reckless disregard for human life, you got second degree. The murder statutes are going to list what the classifications are in the Model Penal Code. In recognizing the death penalty as a form of punishment, death is eligible to all killers who cause the death of another human being purposely, knowingly, or recklessly under circumstances manifesting extreme indifference to the value of human life. Okay? So, I hope that is clear. I'm going to make one more point here, and then I'm going to talk about a specific statute. On the number 3, the reckless under circumstances manifesting extreme indifference to the value of human life encompasses killers with a depraved heart consciously disregards a substantial and unjustifiable risk that his actions might result in death. This is our shooting the gun into the train, okay? And let's go back and revisit our serious bodily harm. If you intend seriously bodily harm and kill the person, this is not going to be a capital offense underneath the Model Penal Code. We're talking about the Model Penal Code here. So the Model Penal Code is recognizing that capital murder consists of 3 things. When you cause the death of another purposely, knowingly, or recklessly. So the serious bodily injury, if you intend serious bodily injury and kill somebody, it's murder 2, unlike the common law. Okay? Now let's talk about some specific statutes. Classifications here. There are some states and some statutes that will deem certain specific methods of killing as premeditated, that the prosecution does not have to show premeditation by the very concept of it being listed in a statute, by one of the facts that appears in the actual circumstances of the case. And the reason behind all of this is that these particular situations are horrible. Like they're heinous, right? Drive-by shootings. If the defendant is in a drive-by shooting, they're using some sort of destructive devices, like a bomb, weapons of mass destruction, ammunition designed to penetrate bulletproof vests. If you're using poison, torture, you're lying in wait, or you ambush your victim, like an ambush killing style, those are going to be presumed. Remember that presumption? Presumed premeditated. That's all that the district attorney has to show is this This was a drive-by shooting. And if it's a drive-by shooting, you presume that it's premeditated. And there, in New York, they have all of these listed. So this is specific. This is involved in New York statute. So these are all listed the same in the statute. First degree murder. I think I already alluded to this at the beginning. What's the highest level of penalty for first degree murder, depending on what state it is? The death penalty. And the United States Supreme Court said murder is the only crime that merits punishment of death. So they don't distinguish between murder 1 and murder 2. They just say murder. But if you're in a state without a death penalty, like New York, the harshest penalty a convicted defendant can get in New York is life without parole. Let's talk about felony murder. We talked about murder in the first degree, murder in the second degree. Felony murder is something that is completely different. It's any death occurring during the course of a felony or attempted felony is murder. Okay? And that felony, that attempted felony or the course of the felony, can be a violent felony or a non-violent felony. It doesn't matter. But there's certainly some problems that occur. And one of them is the lack of criminal intent, right? You didn't intend to kill anybody. That's the mens rea for murder. But you're possibly liable if you've been involved with, if you intended an actual felony and a murder occurs. And as we just talked about, the mens rea for murder is killing intentionally, killing recklessly. We don't have an intent here. This is a strict liability murder statute. And this is, in the United States is the only country that recognizes this law. Okay? Like I said, if you're engaged in a felony and a death occurs, you could be liable for that death or charged with that death. And it doesn't matter if it's you were attempting to do it, bank robbery, gone mad, you didn't get the money, but the clerk dies. It could be a violent felony. Robbery is a violent felony. It could be a non-violent felony. It could just be. Actually, I'm going to get to an example of one of those in a moment. Actually, I'm going to do it right now. So I already gave you my example. The defendant's charged with murder because he robs a bank, and it's robbery because he's got a weapon to shoot somebody or scare somebody or intimidate somebody. Things get out of hand. The guard comes running out and shoots at the defendant. The defendant shoots back and kills the guard, right? Or you have a lookout at the bank while you're in there, and the guard is going to get the jump on you because your back is to the guard, but your lookout sees the guard and shoots the guard. Should you be responsible for what your backup did or your lookout did? Those are examples of violent felonies. This is an example of my non-violent felony. You're on Margaret Street in front of Hobie's. You get into an argument with somebody. In frustration, let's say you get an argument with the owner of Hobie's. Let's say it's the owner of Hobie's, and you're out front trying to toss you out. In frustration, you pick up a large rock and you chuck it through their front big window, which shatters, but a big piece falls, a big piece of glass falls, striking a patron who's just sitting on the inside by the window in the chest, piercing her heart, and she dies the next day from injury. Well, breaking a window is breaking this particular window, and let's say in New York State, criminal mischief in the third degree is intentionally damaging the property of another worth more than $250. We're going to say this big picture window is worth $1,000, so you're going to be charged at the felony level, criminal mischief in the third degree. Oh, and somebody died. Should you be charged and convicted of murder? The answer is that's a non-violent felony, and a death took place based on your committing, because you committed a felony, a non-violent felony. In this case, you could certainly be charged. We'll expand on this in a little bit, but this is an example of felony murder when you're dealing with the underlying crime is a non-felony. And just to be clear, my question is, does transferred intent work here? No, I'm going to make this is a strict liability crime. There is no criminal intent. The transferred intent it transfers the intent to commit it doesn't transfer the intent to commit the first felony to the murder. What happened with transferred intent, it's the intended victim. Okay, transferred intent is victim to victim, not felony to murder. Okay, no transferred intent here. Very important concept. Do you think this doctrine is too broad? Do you think it deters commissions of felonies? I don't know the answer to that. I mean, that would be a criminology kind of question, and I'm sure nobody has like the direct answer to that. I think it works. When I have you do the assignment of choosing a murder statute in New York State to dissect through, some of those will be felony type murder matters if you choose to pick one, and you can decide or distinguish as to why you think it is a good law or not a good law. I want to point out back to this type of felony matter before we do our example, violent versus non-violent. I think the key you're going to have to look for is if the felony being, I know the key you're going to have to look for, if the felony being committed is inherently dangerous to life. It's going to make sense to imply that you have a felony murder. Robbing a bank with a gun, risk of violence or death. Okay? The nonviolent one is a tougher question, but you can still be liable. It might be a lesser grade depending on where you are. You'll have to look at those. We'll see when we dissect some statutes here in the assignments. So besides the mens rea, actually let's do a couple more examples, and then we'll move on to besides the mens rea. We're staying with the mens rea. While Joe is committing a robbery at a grocery store, Tom is the accomplice who's watching the door. A good Samaritan who happens to be shopping and carrying, that I mean by carrying, quote unquote, has a gun, sneaks up near Joe, whose back is to Samaritan, aiming his gun at him and shoots. But Joe incidentally moves, and the bullet strikes the clerk, killing her. So it was the good Samaritan that actually did the killing here, not one of the two folks involved with the felony. Does that matter? Joe and Tom are arrested for murder. I think we're going to come back to this. We're going to have to talk about causation, because Joe and Tom were the cause of the death, were they? So not only do we have an issue with the mens rea, with felony murder, we have an issue with causation. And just to recap, causation, the people have to prove that the actual cause, the but-for cause, and the legal proximate cause. Was it foreseeable? And there's 2 points of view here. Whether or not the underlying felony, if inherently dangerous felony with the risk of death, they're liable in all situations. So inherently dangerous. If that felony they're engaging in is inherently dangerous, it's foreseeable, you're liable for everything that happens. The number 2 view The killing must be in furtherance of the felony. So the killing happens to keep the felony going, i.e. to continue robbing the bank. Okay? So, back to our accomplice. Or I'm sorry, not our accomplice, our Good Samaritan. In a jurisdiction with inherently dangerous felony, even though our two individuals, Tom and Joe, right? Tom and Joe weren't the ones that pulled the trigger, killed the clerk. They were engaged in an inherently dangerous felony. Therefore, the Good Samaritan who tries to stop the robbery by shooting, coming to the defense of others, and shooting the clerk accidentally, Tom and Joe will be charged for that death, or will be liable for that death in some fashion. And in the furtherance of a felony, killing must be in furtherance of a felony. So the killing happens to keep the felony going. Well, what's happening here is it would what? It may stop it, or they might turn around and shoot the Samaritan because of the accidental shooting of the clerk. This one's a little trickier when you have the theory of in furtherance of the felony. I'm going to go through a few more examples here. Do I have it on here? How about this? While Joe is distracted, the clerk grabs her gun from under the counter and shoots at Joe, misses, and hits an innocent bystander. And under our inherently dangerous felony, those guys are going to be liable for the innocent bystander's death. In furtherance of the felony, so the killing happens to keep the felony going, i.e. the continued robbery. Depends what happens next. That may or may not. At this point, Joe might turn around and shoot the clerk and take the money. And if that happens, then that's in furtherance of the felony. How about Joe grabs a innocent bystander and uses as a shield to get to the door, and the police shoot and hit that bystander, killing her and not Joe. This is going to be in furtherance, considered in let's take them in order. I'm sorry. Inherently dangerous felony. Yep. How about in furtherance of the felony? Yes, because he's trying to get out the door. Joe's trying to get out the door with his money or his cash, and he's using somebody, they call it the shield case, and also shield type case, and also he's creating that risk by using a bystander as a shield. What if the police come in and Tom is shot and killed in a shootout because Tom's the lookout? Would Joe be responsible for Tom's death? Well, it is, if you look at the tests, right? In a limited jurisdiction, inherently dangerous, yep. Killing must be in furtherance of the felony. Well, that's going to be a little tougher because it depends on what happens next. If Joe's able to get out of there and continue along, or continue to rob the clerk, if it advances that. But there is an exception to the rule. If it's the co-defendant who is killed, you're not going to be responsible. Not responsible. How about this example? Amber robs a store. While exiting the store, she pushes Ethel, an 80-year-old, who dies from her fall. Amber continues running until she reaches her house. She sits for an hour, has a drink. She hears the police at her front door, runs through the back door, and while she's running out the back door, she pushes her little brother, who falls and hits his head and dies. She's finally caught and arrested. They catch her as she's running down the street and she's arrested. So she's going to be arrested for robbing the store. Is she going to be charged with murder for Ethel? Probably. If she's in a jurisdiction with inherently dangerous felony, risk of death, and in furtherance of the crime, she's trying to get the lady out of her way so she can run. That's in furtherance of the felony. She's going to continue her getaway. What about her brother? She's home. Crime's been done. But then the police come looking for her. She can be charged with felony murder. The rule is that the death has to be part of the same continuous transaction. What do I mean by that? You have to ask yourself, when did the felony begin and when did it end? If the death occurs before or after, you're not going to have felony murder. Okay? So what do we have here with the little brother? We don't have felony murder, but certainly she's going to be responsible for his death in some way, but it might not be murder. It might be manslaughter or something else that we'll talk about in a little bit. All right, a couple more questions regarding felony murder before we move on to manslaughter. When there is more than one participant, like in our examples we have with Tom and Joe, everyone will be charged. Both Tom and Joe would be charged. Who's there, who's responsible. If we take one of those examples we had with when we were talking about we were talking about the parties to a crime. We had Mary, Mark, Joe, and Tom. And we had Mark, who was the driver. If you have a driver in your bank robbery, you have your lookout and you have the one who goes in and somebody dies, a clerk, a guard, not one of the co-defendants. Everyone's going to be responsible and charged with felony murder. I have, would Tom be charged or responsible for the deaths? Yeah, he's the main principal. And then my next question is, what grade is felony murder? And that's going to depend on what the initial felony is and who the victim is. We're not going to go in. This is where we draw out our 50 some odd murder statutes in New York State. To give you some examples, if you are committing a robbery of a bank with a gun and there's a shootout with law enforcement and you kill a cop, chances are that's going to be murder one because of the designation of the victim. And we have several types of felony murder statutes like that. So it's going to depend on who the victim is and what kind of felony is occurring. And when you choose your statute for this assignment, it's one of the things I want you to flush out. There'll be a series of questions for you to make sure you answer. But if you pick a felony murder statute, you're going to have to describe what the grade is and why it is a felony murder and why it would be charged as murder one or murder two. So with that, homicide is over. We're going to turn to, well, homicide's not over, murder's over. We're going to turn to the next section of homicide, which is going to be manslaughter. And if you have any questions, just let me know.